Hello and welcome to this video. This video is on relationship property. So you finally met the love of your life. The world is amazing and everything is just a bunch of roses. Except, how is the Property Relationship Act going to affect you? I know it's difficult when we start a relationship to start thinking about the end of the relationship. It's usually the last thing that anybody wants to think about. But from a legal perspective, it's actually the first thing you need to think about. Especially important for those who are deliberately not entering into a marriage or a civil union. I suggest you go to your lawyer and seek advice on how the Property Relationship Act will affect your relationship and your arrangements with your partner. So what is this relationship or Property Relationships Act as we know it, or commonly known as the PRA? It's an act that has come into force in February 2002 and an act of government, and it basically prescribes what happens to relationship property or property that's held in a relationship when either the relationship is over or when one partner dies. The important thing that this act brought into force in 2002 was that it presumes that each partner to a relationship contributes equally to that relationship, whether that be in different ways. It presumes that if somebody goes out and earns, then the other partner stays home and cooks and looks after the family, and vice versa. So it's important to understand how this will affect you in your relationship if your relationship ends or if one of you pass away. So who does the PRA apply to? It applies to married couples, couples in a civil union, or de facto couples living together. It also can apply to situations where people aren't really in a de facto, however the law may see them as being in a de facto relationship. The requirement, of course, is that any of those relationships have exceeded a minimum of 3 years. Another really interesting fact about the PRA is that it applies to relationships that either end or when a partner passes away. And if a partner passes away, many a times it can override the provisions of a will. This is an extremely important aspect when you are thinking about drafting your will. So the rules for dividing property that are of a relationship of short duration are different for those under the PRA for a married couple in civil union as opposed to a de facto couple. If a married couple or civil union ends before 3 years, however it ends due to the fact that the relationship is now over, then the law states that the distribution to the assets will be dependent on the contribution made by either party. It's not a presumption of 50-50, it's dependent on the contribution made. However, if a partner passes away during a civil union or a marriage, it's treated as if the relationship was over the 3 years. In contrast, of course, we have the de facto relationship situation. A short duration or less than 3-year relationship in a de facto relationship. In contrast, if it's a short duration de facto relationship and one spouse dies, then most of the time the property will not be divided according to the PRA. The PRA will not also be used for short duration de facto breakups if the parties choose to split. So, although the PRA presumes that both parties contribute equally to a relationship, what happens if one party after the split is left with a lot more than the other party is? This, of course, is called economic disparity. So what happens when one partner is left with substantially more than the other partner? Where a court deems economic disparity has occurred, a court may order a split of a different division other than 50-50. Of course, the economic disparity has to be as a result of the division of functions that each partner undertook while in the relationship. If this is the case, it's got to be more than just simply a loss of income. Also, when the divisions are looked at, it can't be based on the fact that one party is going to pay out the other party from their future earnings. It has to be a division based on the property that is current at the time the relationship is ended. If a future earnings claim is to be made by one spouse or the other, there are provisions at law of spousal maintenance. However, in this country, as opposed to other countries in the world, spousal maintenance is something that a court is very unlikely to order in New Zealand due to the fact that we do have very good social welfare benefits in place. So the law recognises that really if somebody is unable to look after their needs, it's not the other spouse's responsibility to continue forever to upkeep them if the relationship has ended. standard. There are, of course, exceptions to this general principle. One of the main examples that I see in legal practice of economic disparity is where, for example, a wife may have been in a very highly paid career. Let's say she's a lawyer, for example, and the husband's also in a very highly paid career, so he's also a lawyer. And the wife decides to give up her job for a number of years, probably 10 or 15 years, to look after the home and to raise children. Of course, when the relationship ends some 15 years later, she has worked to her disadvantage. She is no longer able to earn at the amount that she would have earned 15 years ago had she been in the workforce. Her education is now outdated and her work experience is now invalid, and accordingly she's left herself in a situation of great economic disparity. With regards to economic disparity, a court will examine each case on its own merits, and the mere assumption that one partner earns more than the other does not raise a claim for economic disparity. So now that you've heard all about the PRA, you might be thinking, well, I don't really like this act, Farah. What can I do? Well, you can do something about it. You can contract out of the PRA. By doing this, you'd need to actually have a solicitor draft up an agreement, a contracting out agreement, and you and your partner would need to come up with what the terms of your property split would be if your relationship ended or if one spouse passed away. The requirements, though, for contracting out of the PRA are quite onerous. You would need to both seek separate independent legal advice. You would need to be certain in your decisions, and those decisions would need to be explained to you on separate occasions by separate lawyers so that you fully understand what you're doing. There are also drafting requirements, and so I urge you to make sure you do seek expert legal advice in this area and not just go to a lawyer who may not be practicing in these areas day in, day out. Of course, the result of not having a valid contracting out agreement, if you like, means that, of course, the PRA will apply. So, as you would have now realised, talking about a breakup or relationship property division at the very beginning of your relationship, although it may seem pessimistic, untrusting and opportunistic, it is extremely important, and I urge you both to do so. If you truly do love this person that you are with and you are embarking on a genuine relationship and you wish to see it through to the end, it's really important to openly discuss these issues. At the end of the day, if they're discussed and dealt with initially, it will save both partners much heartache and much grief over the years. I trust you found this topic interesting and helpful, and if there's any further questions you may have, you can feel free to go to the Facebook page and to email those questions through. I'm Farah Khan, your lawyer.